Please take your seats. We're ready to resume. Yeah, I saw my note. Thank you for that. That although that was a working dinner, it was not paid for by the taxpayers. It was paid for by a taxpayer, but not taxpayers, plural. All right, we were, as I recall, just at delegate, almost promoted you, Delegate Harshberger. Questions? And Mr. Canterbury, you're still under the same oath.
Yes, sir.
Thank you, Mr. Chairman. Thank you, Mr. Canterbury, for still being here. I just want to kind of dig in a little more to these change orders. The original agreement, or I guess you say purchase order with the contracting company back in 2009 was like for $500,000 or $800,000. Is that correct?
Yes, it was $500,000 if memory serves.
So when the court issues that, is that based on a scope of work? Because you said you didn't have to bid anything. So is that just basically, so there's no dollar value associated? See, that's where I'm baffled, is how that division order or purchase order is determined. Is it by the scope of work or the dollar value?
We didn't have to bid it, but we actually did bid the initial construction. So Neighborgall won the bid. They looked at the scope of work. They submitted the bid. Theirs was the lowest. They got the job.
Okay, so the following change orders, did they have to submit a new price for that change order if there's another project coming up, an estimated cost?
Yes, and they were told that I wanted to see what their price would be for the change order for the clerk's office was the next big chunk out of this, or I'm not sure if that came before or after the courtroom renovation, but I let them know that if I felt that it was excessive, we could always bid again.
Yeah. Now, did this same original purchase order cover the remodeling for the justice's office?
No, the original, when you say purchase order, I think what you mean is the bid covered the fourth floor chief counsel's office, which is basically half the east wing of the building.
Okay, so that original 2009 agreement does not cover the justice's office or
that came with change orders, and that's why there's so many. There were individual change orders for each of the offices, and there was an individual change order for the courtroom. I've got a frog in my throat. I'm sorry.
Okay, so there was a change order, say to do the renovations to Justice Ketchum's office. There was a change order, correct?
Yes.
So there had to have been an idea or ballpark cost associated with that.
Well, yes. They talked to the justice, talked to Silling, got an idea of what they wanted, what he wanted, what they thought needed to be done. Based on the scope of work that was presented by Silling, they then presented a change order, as I recall.
Okay, so then the change order would be the same thing for all the other justices' office. When the new project come up, they'd kind of get a rough idea saying it's going to cost X amount of dollar for these renovations.
Right.
Okay, so...
But there were unexpected costs that were associated that came up.
Okay.
And they were, in some cases, they were simply added on. In other cases, there was an additional change order.
Okay, and if I remember right back in my previous questioning on the first round, these change orders, you said they were discussed among all the justices, and you eventually were the one that signed it. So they were aware of the possible cost on these remodeling.
Yes.
Okay. So
although I don't think they were aware of each of the costs. They just knew that there were going to be change orders that were handled in order to keep this construction company on the job, and the people they'd gotten to know and liked and felt that they were respectful of their work habits. A lot of this had to do with them feeling that the neighborhood hall construction people would not work and make a lot of noise when they were in court. They would not be bothersome when they were in opinion conference. They would work around their schedule, and they found them compliant and excellent, and so that's why they wanted to keep them.
Based on their previous work.
But I don't recall that they saw actual numbers for the change orders for the individual offices. I think they did for the clerk's office because that was very expensive, and I think they might have, I can't say if they did for the courtroom or not, I just don't recall.
Okay. The JIC reported, I think it's on page 3, and I think it's also been reported elsewhere, that Justice Lawfrey's office was approximately $363,000 for renovation cost.
That sounds about right, and that does not include the furniture, does it? I think it was just, I mean, maybe I'm misremembering. Maybe that does include furniture, and it was close to $300,000 for the actual construction. I frankly don't remember.
Yeah, and that's where I'm going with this. Do you know how much, it goes back to the previous question I asked about Justice Davis, how much of that was actually for structural and...
Right. I would say it was probably about the same ratio in Lawfrey's office.
So there was a...
Well, no, actually I wouldn't. I would think it was a higher ratio because every stick of furniture in Lawfrey's office was bought by the state. He didn't have a single personal piece in there. From the frames on the wall, as I've discussed, to every chair, everything. It was all bought by the state. And in Davis's office, there were a couple of expensive purchases, but the vast majority of the furniture in her office, her desk, her couch, her chairs, her coffee table, things like that, they're all hers. I mean, at her expense.
Yeah, I just did some quick math on some of the big ticket items that was reported for his office, and that ended up being about $60,000 for the furnishings, and he said there's some more. So that still left about $300,000.
Right.
So, but you say some of that was structural or HVAC?
Some of it was structural, some of it was casework, a lot of built-in counters, cabinets, things like that. Okay. And it was very expensive because he wanted sculpted walnut. As I recall, the sculpted walnut alone was $100 and some thousand because he wanted wainscoting out of the walnut, very expensive. And he also wanted the walnut to match the cabinets throughout, and so it was all sculpted walnut, the doors, etc. I think also the radiator covers were, so that was not cheap. But again, if you have the documents, you can review them. I don't have them, so I can't really review
them. And let me just mention to the committee that we expect to have documents to submit tomorrow that have been analyzed and they've been broken down in various ways, and we'll have a member of the Legislative Auditor's Office to be here to answer some questions. So this witness probably isn't going to have the kind of detail that we'll get tomorrow. Okay. So just, and one other reminder to our members and also to our witness, with our court reporter here, it's hard for her to take everything down when both parties are speaking at the same time. So I would just encourage the questioner to wait till the answer or the responder finishes before you start the next question. And
will do. I know there's been a lot of talk about this, about the $7,500 floor medallion, but also, you know, there's been a reported cost. There's, you know, for Ketchum's office, there's $12,000 worth of carpet. I mean, and that, I believe your statement was that his office was remodeled before Lawfrey's office, 2009.
Yes, it was.
Okay, so then Workman's office was also before Lawfrey's office.
Yes, it was.
And I think it was reported that there was a $9,000 sofa purchased for her office.
That's not exactly right. It was a $9,000 reupholster. She owns the sofa. The state owns the upholstery. I don't know how you divide it up, but that's the way it is.
Okay, that's interesting.
I found it to be interesting too, sir.
Okay, that's all I have. Thank you, Mr. Chairman.
All right, back to the right side of the room, first row, Delegate Lane.
Thank you. I'm going to try to talk and keep this on. Let me know if you get feedback. Mr. Canterbury, I have a copy of this year's budget.
Okay.
And for the court, for the judicial system, and the budget's $139,759,000. Approximately how much of that budget would be for the Supreme Court operation, just the court itself?
Well, I've never been asked that, so I'm going to have to kind of calculate for a second. I doubt if it would be more than 12%. Maybe you're talking about the Supreme Court itself, or you're talking about administrative office, the clerks, the...
I'm talking about the operation of the operations in the East Wing.
Okay. I'd say it's closer to probably 18%, but again, it's been a while. I don't know that I can say that with absolute assuredness. But so much of the expense of the court system is in the field with circuit judges, family court judges, probation officers, mental health and commissioners, magistrates, ad infinitum.
Okay. Now, going back to a follow-up question that the delegate from Boone asked, court has 2 security guards.
3.
One of them's over at
City Center
East. So, and you said that Justice Davis never drove herself, that she always had someone drive her, and I think we had prior testimony that that was the security person.
Yeah, yes, that's true, Delegate. Neither Justices Davis nor Workman drove themselves. It was always a security person driving them. At times, the other justices had security people driving them, but always Justices Davis and Workman.
Well, who was securing the court when the security guards or the security personnel were out chauffeuring justices?
There was a retired state trooper who was on call, and he was contracted to come in. Of course, there were 2 at the court, so quite frequently it would just be 1 on the road. And if all the justices were at a meeting, the security people would be there, and there would be nobody as the security person at times, and at other times they would feel that they needed to have the contracted person.
Okay, and you testified that there had been threats against the justices?
Yes, against some justices.
And is that why the justices asked the security personnel to drive them places?
I think that's part of it, and I think, frankly, some of it was, well, for lack of a better word, chauvinism from the 1990s. Justice Miller felt strongly that Justice Workman should never drive. I heard this. I wasn't there. I heard this story, that she should never drive herself.
Okay, but let's talk about...
But that's just apocryphal. I don't know if that's true or not.
Sorry.
Me too.
Sorry. Let's talk about Justice Davis.
Yes.
So she never goes any place without being driven by court personnel.
If it's a state car, that's true.
And part of that, you said, is for her own safety?
Yes.
Okay, so does she have a guard when she goes to the supermarket at night? Because she would be out there in the public and theoretically would be unsafe there too.
At the height of this, I do not want to get into too much detail, but at the height of this, yes, Mr. Siegel and Justice Davis did have private security that they paid for themselves.
So,
but that was at the height of the matter before they rounded him up, and I think he went to a mental institution.
Okay. So I think you testified that the justices had computers at home and that it was necessary that the computers be secure.
Yes.
And did that require court personnel going to the residences to make those computers secure, or is it a matter of, I think one of the prior witnesses talked about, it was really just a matter of logging into the secure network?
Well, both things are true. The initial setup to make sure that it was a clean system and a clean line that they were connecting to, you had court personnel go to set them up. After that, they just needed to log in, and then it could be, if they felt that there was somebody doing something they shouldn't through their system on their computer, then out of the central office, they could take a look and see if there was some sort of problem. It's perhaps hard to believe, but we had 3,000 to 3,500 attempts every day to get in illegally to the system, most of them with North African originating addresses.
Did anybody ever check to see if the justices were actually doing work from home on the computers?
No.
This is sort of just an off-the-wall question. We've heard all about these Cass-Gilbert desks, and we've heard that at least one of them has been valued at $42,000, and there are of historic value, but it doesn't appear that any of the justices, except maybe Justice Ketchum, ever used the Cass-Gilbert desks. Why are the justices not using these desks?
Well, also Justice McHugh used one. Well, it's a matter of taste and a matter of what they feel they can use. These are big, kind of cumbersome desks. They're perfect for the 1920s era.
But it's still, but the size of the chambers hasn't expanded.
Oh, no, they'd fit, but you're right. But they're two used by law clerks. There's one used by the security director, Arthur Angus. I don't know why they don't want to use them. It's one of the few legal phrases I know in Latin, de gustibus non est disputandum. Matters of dispute, the matters of taste, there can be no dispute. Some people like shorter, smaller desks, I guess. I don't know.
Okay. Now, the justices are all on the 4th floor. Is that correct? No, the 3rd floor.
3rd floor.
3rd floor. During your 11 and a half years at the court, was it your observation that the justices interacted with each other in each other's offices or not?
Different strokes for different courts. My original experience was that Justices Starcher and Albright were pretty fast friends. They frequently in one of the other's offices talking. Justice Maynard got to know Justice Benjamin pretty well. They'd talk a lot. Justice Davis would float in occasionally. Later, when Justice McHugh was there, he was really a wonderful person to hold people together, among other things, and all of the justices talked frequently among themselves. It was a very collegial court. Those 4 years were golden years for collegiality. It was remarkable just how easy the interactions were. But when he left, some barriers started to arise between their interactions, and Justice Ketchum and Justice Laughrey spent a lot of time talking, sometimes, and Justice Laughrey and Justice Workman interacted a lot, sometimes with Ketchum. Justice Benjamin and Justice Davis would talk, and they had a good relationship. I think everybody kind of tried to get along, but I think there were some it wasn't like it had been.
Well, would it be fair to say that when the renovations were going on, that the justices would have been in each other's offices and could have observed what the renovations were?
Well, sure. I'm sure they would see things. Whether they knew it's like The Price is Right. Would they know what the couch cost or what the chair cost or any of that? I don't know that they would have known that. And I always kept it between the justice and me. I mean, unless the justice wanted me to go telling the other justices, I felt one of the harder parts of the job, I think I mentioned earlier, I had to serve the court, which was the majority of the court, but I had to serve each one of them individually. I did my level best, which means that I had to keep certain confidences if they seemed to want me to keep the confidence. Of course, if I felt the confidence was out of line, I would take it to administrative conference. That rarely happened, however.
Okay, one final question. I can't remember, but somewhere in all of this, it was said that Justice Benjamin spent either it was $122,000 on travel, or maybe it was $222,000, something like that. How could you do that much? How could you run up that much expense?
Well, Justice Benjamin felt that the court needed to have somebody who did some outreach to represent the court on the road. And he started that right after he got elected. He felt very strongly about that. So he made a point of going to all the drug court graduations. He made a point, if there was a rural county with a small bar association and they had invited any justice to show up, he'd drive to the Eastern Panhandle, or he'd drive to the central part of the state. And the reason that he built up the expenses is because Justice Benjamin is more of a Boy Scout than just about anybody I've ever met. And he believed that he should never take a state car if he was going to go anywhere that wasn't related to the state. Well, while he was out to the bar, he might want to go visit a pal who lived nearby, or a kind of circuitous route back, and he didn't think it was appropriate for the court to pay. So he would simply have the MapQuest figures for how much it cost, how many miles it was from the Capitol to wherever the heck he was going, and have that computed. It didn't matter how many miles. He actually put on that amazing old Toyota. I was always terrified that Toyota would break down in the middle of nowhere. But he always felt that it was the only way he could do that and be honorable. And that's the way he did it. He's one of the most honorable people I've ever known in my life.
Okay, thank you.
Delegate question?
Thank you, Mr. Chairman. You stated that the threats against Justice Davis were, I don't know if you said taken more seriously than others. We said they're obviously taken fairly seriously. The gentleman who was eventually picked up, was he considered to be part of like a larger group? Is that why it was taken more seriously?
No, it was the vitriol and his specificity, and he had knowledge of their movement and other specifics. And I don't know that he was ever part of any organization. I never heard that.
No, he never claimed to be part of any sort of paramilitary?
He may have, but I don't recall that. Okay. But he had that. You've got the right kind of mentality there. Also, I don't know if he's still institutionalized or not. I know that he was. He may be out now for all I know, and maybe they fixed him. I don't know. But I don't think there were any recent threats from him.
Okay. The storage area downstairs.
Yes.
You mentioned, this is the first that I've heard of that.
Right.
You said that's where a Cass Gilbert desk should be stored because there was there's a rule in place that it should not leave the Capitol. I guess it's a statute, correct?
Yes, I believe it is.
State law that those desks can't leave the Capitol.
I think memory serves it's 2917, but I'm not the lawyer around here. I think it's 2917.
2917? We have confirmation from our accountant.
Well, if Joe says it, it must be true.
Yeah. So it's state law that it's not to leave the Capitol. Was that the reason for the storage area downstairs, for items that are not allowed to?
I don't know. The storage area I inherited, I don't know why it was there, but that's one of the reasons it was used. There were other things in there, documents, not clerk's documents, but documents, some various and sundry things that justices had in their offices and decided they wanted in storage instead of in their offices, framed certificates, things that were honorary plaques that had been given them, and they wanted to keep them, but they didn't necessarily want them in their offices. And just it was a mixed bag in that room. It's not a very big room. It's a relatively small room, but it did have enough room to put a couple of case goods, pieces of furniture. And so I think that, at least my thought was make sure that if we have a Cass Gilbert thing, don't let it stray over to the warehouse. That's my feeling about it.
Do you know of any other items in the Capitol that are specifically named in state law that are not to be removed from this building?
I think everything that you're sitting in, and you might laugh at that, but the Minnesota State Capitol lost some of those desks, and they were sold in the open market that had been in legislators' chambers. From reports, I wasn't there, but I read that. Architectural furniture is a very hot property right now, so I think anything that was originally chosen by the Cass Gilbert firm is supposed to stay in the Capitol. And I don't know of anything else that's designated in there. I just remember the Cass Gilbert reference.
Okay, well, I can't speak for everybody. I'm just learning today that was actually not just a policy of the court, but actually state law. Is it widely known over in the court that is state law, that those desks are to stay in the building?
I wouldn't say it was widely known at the court, but it was widely known among the more alert members of the Capitol Building Commission.
So would it be known by someone who served as a clerk at the Supreme Court for 11 years and then was later a chief justice?
I don't know if he would have known that or not, to be perfectly honest, but I didn't know he took the desk, so I didn't have any opportunity to think of telling him about it. So I don't know.
Okay. One more question. The female employee that I guess spoke with you, and you later spoke with then Clerk Lawfrey, she stated she didn't want to follow through with any sort of formal complaint or charges as long as it stopped.
Right.
And it stopped?
It stopped.
Okay. And one follow-up question: did she? How much longer after that did she remain employed at the court?
Until she left for school in the end of the summer. I mean, she didn't go except because she decided it was time to go. She was a temp. She wasn't a permanent employee.
She was a temp.
So she was there roughly from, gosh, this is hard to remember, but it was in 2006, January, February until August, maybe September, whenever, and then she went off to school.
Okay. Thank you.
Sure.
Delegate Holland, Overington, Delegate Overington.
Yes, thank you, Mr. Chairman. It sounds like when you had 4 desks of the Cass Gilbert desks, the good news was you didn't have the 5 justices battling for them.
That's true. Yes, sir.
For the administrative meetings that you had that were every month or two where you attended most of them, were any of those meetings recorded?
No, the meetings were never recorded, never. Did you just ask if the meetings were recorded? I kind of coughed for a second, but none of the administrative conferences were recorded in any way.
Were any other meetings recorded?
Not that I'm aware of. If they were recorded, they were done surreptitiously. There was no official recording.
I know here at the Capitol, here in the House of Delegates, every year the staff tells us that we have our Ethics Commission reports that we have to fill out.
Yes.
And sort of as a reminder, there was nothing in your office where you did that for the justices?
No, I think they were sent directly to them by the Ethics Commission. I know I always got mine directly from the Ethics Commission, but they also had to file something with the clerk's office, the clerk's version of the ethics statements, as I recall. I had nothing to do with that. That was a clerk's office function, but I think they had to file something every year with them, but I don't know if it was as comprehensive as the ethics form that I always had to fill, that I always chose to fill out. I think I had to fill it out, and I always did.
Do most of the staff for the court have to do an ethics report?
No.
Do the judges have to do one?
And I think the judges, the circuit judges, family court judges, that's why I think there's something filed with the clerk's office, but I swear I just never had anything to do with that, so I'm not conversant enough to tell you much.
Would the assumption have been that if the judges do it, the justices should also do it?
Sure, and I think that the justices filed with the clerk's office, but I don't think that they may have, I don't know if they submitted stuff to the ethics office or not. But I know that there was some question early on about whether or not they needed to or should. But that was in the first few years I was there. The later ones might have thought it was just a matter of, another office thing to do. I don't know.
And my last question, was there any policy about bringing private furniture into the court?
No, you could bring in your personal furniture if you wished. Justice Workman, Justice Benjamin, Justice Davis, I all had personal furniture in our offices. Justice Lawfrey had absolutely nothing that wasn't paid for by the court. And I don't think Justice Ketchum did either. I think all of his was state furniture.
Thank you. Thank you, Mr. Chairman.
Delegate Fast.
Thank you again, Mr. Chairman. Mr. Canterbury, have you ever attended any fundraisers for Justice Davis?
No.
Okay. Wanted to ask you some questions. There was a memorandum by Justice Lawfrey writing to the other members of the court, and he stated that there was no written policy regarding use of court vehicles by either members of the court or court employees. Is that true?
There was nothing about I think that's true, yes.
Okay. He also stated that that you had utilized a court vehicle on 38 occasions without providing a destination.
That's true.
That's true.
Either Arthur Angus didn't write it down, or my secretary and executive assistant didn't get him the information. I never did that. It was always her doing, so I don't know what happened.
Okay. He stated that on at least 8 occasions, Justice Benjamin checked out of court without stating a destination. Is that true?
I read that. I'll assume it's true, but I don't know that.
Okay. And that Justice Workman had use of a vehicle without a destination being supplied as well, that there were entries of that. Do you know if that's true?
I believe absolutely in the auditor's report, so I'll say it's true, but I wasn't part of it. I will also say that that would have been a failure on the part of one of the security staff, because not only were they the security people, but they were in charge of entering that information. Justice Workman would not have gone in and entered the information herself, for goodness sakes.
And likewise, Justice Davis did not list a destination on her use of a court vehicle on multiple occasions. Would that be true?
Again, that's what was in the report, and I have no reason to disbelieve the auditor's report. However, again, I would say that that would not have been a failure of Justice Davis. It would have been a failure of her Arthur Angus, who not only was the driver, but also in charge of the system.
So lack of entry of a destination for any justice, are you saying would most likely be a failure on the part of the staff versus the individual justice?
Of course, the justices have to be responsible for staff does, and in that sense, it falls back on them. But also, they didn't do the entries themselves; they were done by Arthur Angus and/or Just Gundy, and so since they were doing the driving and then they didn't enter the information, then that would have been their omission, not the justices.
Okay.
Just as I said about my secretary calling up, maybe she did, maybe she didn't.
And what about for you? Were you responsible for your own entries, or did you have staff for yourself as well?
Ultimately, I'm responsible, but again, I had Joan Mullins was the person, or in some occasions Mary Green was the person who was supposed to call up and say, Steve's taking the car to X, Y, and, to X for this purpose, that purpose. And either she didn't make some of those calls, or they took the call and didn't put the information into the system. I don't know where the breakdown was.
Okay, and while campaigning to become a justice of this court, he personally observed Justice Davis arrive on more than one campaign event in a court vehicle driven by court security. Do you have any knowledge of that, or whether that's true or not?
I have no idea.
Okay. There was some communication between Denny Rhodes, West Virginia Legislative Auditor's Office, and Sue Racer Troy, and he had sent her a summary of a meeting and asked for accuracy. And there was one, this is Exhibit 14, number 5, second page. It said, the court, and right here she's quoting what was in this summary, and then she responds to it. The court used the Fixed Asset Inventory Management System, WVFIMS, but from her inspection, it appears that the court had not updated or utilized it since 2010. Mr. Canterbury had informed her this was intentional because he did not want others knowing the court, I assume means what the court had. Since 2010, even IT inventories such as server, routers, computers, etc., had not been recorded. The IT department of the court may have kept an internal record in an Access database. And then her response was, after returning to the office on Monday afternoon, I reviewed the fixed assets in FIMS. The latest acquisition date for technology equipment, servers, routers, computers, etc., is 7/9/2010. No technology equipment was added after that date. The last acquisition date for vehicles is 9/24/13. No vehicles were added after that date. Now, her response right there, is that true?
No, not entirely. As I said earlier, as we transitioned from FIMS to Amazon to Oasis, there was a breakdown of keeping records. I'm not sure why Ms. Troy didn't keep the procedure that Mike Proops, her predecessor, had established, but I certainly never told her that I wanted to keep from the public any of the information about what the court had. As she says further, commenting
I haven't got to that part yet. I'm just asking about the entry of the data in the system.
Apparently she stopped entering it and felt that it was somebody else's responsibility, I guess.
So that was her misdoing.
Well, it had been her predecessor's job, so it would have been her job too.
So was she under you?
Oh, yes. So it falls back on me ultimately.
So is it true that the last acquisition data for technology equipment such as servers, routers, and computer was July 9, 2010? And she wrote this in March of 2018. So is that an accurate statement right there?
I can't say if that date's accurate, but I also know the IT department decided that they wanted to keep their own records and to take that out of everybody else's hands because they felt that some of the information wasn't being recorded properly. So they started doing it on their own. I think she references that as well.
Is it true that no vehicle acquisitions were recorded since, or
well, there were only 19.
The last acquisition for vehicles was September 24, 2013. Is that true?
Could be. I'm not sure that anything was bought after 13. When I was there might have been, but there were only 19 vehicles. There was a list of them. I presented that list in the spring of 16, as I recall, to Aaron Allred when he requested it. And so I submitted the list of vehicles we had. It was only 19 vehicles, so we knew what the vehicles were. We just may not have had them in the system she's referring to.
Okay, then she goes on to re-quote the summary again, quoting, Mr. Canterbury had informed her this was intentional because he did not want others knowing what the court had, end quote. And she said, I don't recall that Mr. Canterbury told me this specifically related to the fixed asset inventory. He often referred to being a third branch of government, and the independence of that came with that. I felt that best practices were not always followed due to wanting to exercise independence. And then she goes on. So you dispute that you told her that that was on purpose because you didn't want people knowing what the court had?
I didn't tell anybody to hide anything. That's not my style. I didn't do that. I did, though, frequently talk about that we were a third branch of government, frequently OASIS especially, and she was up to her eyeballs in OASIS, kept referring to the court as an agency, not as a branch. They didn't seem to really know how to compute us. And they just had a hard time understanding it. And I think in lots of discussions with her, I would say, when you're in there, remind them that we're a branch, we're not an agency. No, we don't work for the governor. No, we don't respond like an executive agency. There was a need to make sure that there is an independence to the three branches, and I did emphasize that. But in relationship, as I recall, with the OASIS, situation, I'll say.
Okay. Quick question about the floors. Which floor was more expensive, Justice Workman's floor or Justice Lawfrey's floor?
I think Justice Workman's was more expensive. Even with the medallion, I think hers was more expensive. Again, though, I don't have the documents in front of me, but that's just what memory serves.
Okay, when you were terminated in 2017, were state vehicles used to transport your items to your home?
I said that earlier, yes.
And were state vehicles ever used to transport any of your personal items into the Capitol?
No, I brought them in my own vehicles.
Thank you, Mr. Chairman. Thank you.
Delegate Capito.
Thank you, Mr. Chairman. During your time on the court, did you or, to your knowledge, any other employee or employees of the court receive bonuses or any other additional compensation from any of the justices?
No, the bonuses aren't allowed. There were no bonuses.
Not even personally from any one of them? Out of their personal?
Not that I'm aware of.
Okay.
I never got one. So if somebody
enough.
else got one, I am now even angrier.
Fair enough. Thank you for being here. Thank you for your patience.
Delegate Flashhour. Mr. Canterbury, the name Zach Johnson has come up a few times, and I think he's somehow associated with the construction and maybe even became an employee of the court. Can you help me follow that?
Zach was extremely popular as a construction person. He's a very good construction man. He's good. He's a I think he's a union carpenter by training, but he's just really knowledgeable about all matters of construction. Justice Ketchum was extremely impressed with him and brought up, I think at administrative conference, I think he brought it up with me personally a few times in an administrative conference, that he thought that we could use somebody to go around and perhaps save the state a little money by Zach taking care of a lot of this stuff that we were at the magistrate courts and at the family courts for some repairs, some minor construction, and rather than having to contract it. And so he was hired by the court, and he worked under the watch of Kim Ellis.
Do you know what time frame he basically transitioned from working with an outside contractor to when he became a court employee?
You know, I'm not 100% sure, but I'm going to say 2014 or 15. It was after either towards the end of the Davis project or after it was over.
We have information that he may have appeared in one of her campaign commercials or her husband's commercials. Do you know whether or not that's true?
I don't know about the husband's commercial, but yes, as I recall, I wasn't involved with the making of the commercial, but I saw them, and I think Zach was in one of those commercials when he was still working, not for the court, but still working as a carpenter for a union carpenter, I think, for Neighbor Girl still.
And was that in Justice Davis's commercial or her husband?
I think I've never seen him in. I'm one of those people who changes channels on commercials, but I do watch the political ads. I can't really tell you much about Scott Siegel's commercials, but I don't recall him being in any of those that I've seen. But he definitely was in one of, or maybe a couple, but at least one of Justice Davis's ads.
Before he was hired by the court?
Yes, before he was hired by the court.
I hesitate to ask this next question, but I've been asked to do so just to dispel a rumor. There was a rumor going around that you were communicating directly with one or more members of our committee during our proceedings. Is there any truth to that?
Yes. I texted a person who asked me a question, and I texted him back and texted him a few other times.
Okay. Can you identify who that was?
It was Andrew Robinson, Delegate Robinson.
And was it more than one occasion?
A couple of days, a couple of different texts. I really don't know how many.
All right. Final question. One of the tasks of this committee is to come up with recommendations for changes in legislation. And you were intimately involved with the court for 11 and a half years, if I calculated right. Do you have any suggestions for our group as to what suggestions we should make to the House as to changes in the legislation affecting the court?
Well, one you've already done, I strongly believe, and this will strike some people as surprising unless you read my op-ed in the Gazette. I never believed that the court should have control of its own budget. I thought that just was an imbalance to the balance of power. I think the legislature is the purse keeper, and you should have that authority. Also, just strategically, I always thought that whenever you folks see judges, magistrates, family court judges around, you think one thing: it's pay raise time. They're up here lobbying for a pay raise, and that brings a very bad impression of them. But if every year, while the budget's being developed, you interacted with all of those people from the court, you would start to have more understanding of their jobs. You wouldn't think that they were just money-grubbing pay raise people. And they would have more understanding of the challenges you face in trying to balance everything. That can't help but be good to have that kind of familiarity. So I always believe strongly in that. But, I work for them, and after that initial conversation with Spike Maynard, he said, never mention that again, and I never did until I was gone. The second thing I would suggest, and I feel strongly about this too, you may know that I played a pretty instrumental role in community corrections work. The criminal justice reform work and criminal justice reinvestment. Justice reinvestment is really valuable. Take a look at Connecticut and see how their numbers of crimes have gone down and their numbers in institutions have gone down. But as long as the probation officers are working for the court, they will never, ever do what they need to do to make this work. They simply are not under your watch. And I believe that, like the vast majority of states, only 13 or so states have probation officers who are under the court's watch. I think there should be a separated division of probation and parole. Parole should be brought out from DOC. Probation should be brought out from under the court. And then they should have to follow the dictates of this body to make sure that they're doing the work they need to do to lower the numbers of people who are recycling back into prison. Now, here endeth my lecture. I could really go on a long time about this. I know a lot about it. I was very proud that I was able to get the Justice Center to bring $4 million to the state along with Governor Tomlin and to help us get the statistics we need. You've got a great start on juvenile justice. You need to see it through, and I'm a little concerned that the legislation that combined juveniles under the watch of the agency that also has adult offenders. that doesn't work out very well in most states, and I think that you better watch very carefully to make sure the juvenile justice reforms work. Look, we don't have to have this recidivism. We could lower the crime rate dramatically. It just takes being smart. Look at what Texas did. Look at what Connecticut did. They have the lowest crime rates in their history. And can you think of any two states that are more different than Connecticut and Texas? Well, they have one thing in common. They got into justice reinvestment and they did it right. You can too, but it's up to you to have the will to do it.
Thank you. Thank you, Mr. Canterbury. And I do need to correct one thing. The name I said was Zach Johnson. It's Thompson.
Yeah, I didn't think Johnson was right, but I was having a crisis of memory, and I thought, is it? I thought it was Thompson.
It is
But
Thompson.
I knew exactly who you were talking about. Zach's a good man.
All right. Thank you, Mr. Canterbury. Counsel, any
Thank
further
you, sir.
follow-up? All right, you're excused, and we appreciate your endurance tonight.
Sure. Thank you.
All day, yes. To the members of the committee, just a brief sort of overview of what we're going to do tomorrow. We will have some information for you regarding the construction costs. It's the Legislative Auditor's Office has been doing a lot of work. They had a huge notebook full of invoices and so forth delivered to them. They've made an effort to analyze that and to summarize it as well. Our executive assistant over here has done some charts that hopefully will be helpful to you. We'll start with that tomorrow. We'll entertain some questions about that, although as I said, the documentation is pretty overwhelming, so I'm not sure how much beyond the scope of what the charts and so forth show we'll be able to do, but at least you'll have that information for the next week. We also will be developing some information regarding this issue of working lunches that the JIC dealt with, and one of our staff has basically done an analysis of those, and you can decide for yourself whether the working lunches all occurred during administrative conferences and so forth. That's part of the information. There's some information that our managers have developed, and particularly Delegate Miller, on the Greenbrier book signing excursions, and we'll have some information and documents to share with you then. And finally, some information on that Tucker County Magistrate case that was mentioned in one of the JIC, I think it was the JIC charges. And that will be probably what we'll be doing tomorrow. And so I don't expect we'll be here all day or even late into the afternoon. And as I said earlier, we won't be here Saturday. Now, I would like to meet with the managers for a few minutes after this meeting so that we can finalize our agenda for tomorrow. And for future purposes, here's what we're facing. Because the JIC has concluded their investigations that were focused on the lunches and a few other issues, that information, which was out of bounds, so to speak, because of the confidentiality provisions of the JIC's procedural rules, we have subpoenaed that information, but we've also been told that it won't be available probably before Wednesday of next week. And if it's anywhere near as voluminous as the last series of information we got, we're going to need some time to digest that. We also have the handicap, we're going to have 2 of our staff members gone next week, and we also have given Ms. Lawfrey some additional time to get counsel. So we're not going to meet on our normal schedule next week, but we probably will meet the following week early. And we're thinking at this point by maybe mimicking the interim schedule, since we're not having interims in August, and maybe do a Sunday afternoon, Monday, Tuesday. We have tentatively confirmed the tour for the Supreme Court facilities on Monday. And so please pay attention to our emails. It's possible if we don't feel like we have enough information to spend Sunday, Monday, and Tuesday, we may just wait till Monday and do a long day Monday, sort of like what we've done tonight, and then Tuesday rather than 3 days. So pay attention. We'll be bringing you up to date. It's going to take us a little while to figure out what to do with all this JIC information, how to present it if we feel like it's necessary. So with that, I'll entertain a motion that we be in recess until, let's just say, Sunday week, the 5th No, I'm sorry, tomorrow morning, 9 o'clock. Tomorrow morning, 9 o'clock.
Mr. Chairman, I move the committee stand in recess until 9 a.m. tomorrow.
You've heard the gentleman's motion. All in favor will say aye.
Aye.
Opposed, no. The ayes have it. We are in recess till tomorrow morning.